Everyone, we're going to go ahead and get started. Hi, everyone. Welcome. Thank you for attending the board's Lunch and Learn webinar series. My name is Allison. I'm the Public Information Officer for the Nebraska Board of Engineers and Architects. With me today is Amy Habe, the board's Compliance Officer, and Board Executive Director John Wilbeck. They'll be helping with questions and monitoring the chat box. It's important to note the questions asked via the chat box during the webinar today will be addressed at the end of the webinar. Also, everyone is muted for the presentation, so the chat feature is going to be the only way that we for you guys to ask questions. Additionally, wanted to let everyone know the webinar is being recorded and it will be updated to the board's YouTube channel. So if you're unable to stay for the whole presentation or would like to reference it later, it will be posted on the channel. It is important to note that this will be offered here, but watching the video through YouTube will not count as CE credits. Additionally, the slides for the presentation are on the webinar information page under the webinar materials section. Their slides are they're going to be full pages of each slide or 3 slides to a page, and with the ability to take notes to them. So you can directly type onto the PowerPoint or the PDF, excuse me. Lastly, for those who participate in the entire presentation, an email will be sent to you within the next week confirming your attendance and possible use for continuing education credits. If you do choose to use this for CE credits, please use the email I send as attendance verification, as there will be no certificate issued. I do anticipate the board giving credit for the webinar, but as a reminder, the board does not pre-approve any CE offerings. So let's go ahead and get started. So during the webinar today, we'll be going over enforcement, the complaint process and investigations, penalties, case studies and sources, coordinating professionals, and technical submissions. So first, we are going to take a look at enforcement. So the Nebraska Engineers and Architects Regulation Act Handbook. This contains the Regulation Act and the rules and regulations of the Nebraska Board of Engineers and Architects. These statutes and rules govern the practice of engineering and architecture in Nebraska in order to safeguard life, health, property, and promote the public welfare. So the first section presents the statutes as cited in the ENA Regulation Act. The most recent changes to this were enacted through LB 755 and became effective November 14, 2020. The second section is the rules and regulations of Nebraska Administrative Code, chapters 1 through 10. These rules and regulations are written by the board to enable the administration of the statutes and cannot exceed the powers assigned to the board by the legislature. And these rules and regulations were last updated March 16, 2024. Within the handbook, Rule 10.3 occupancy classification table is in there, which is used to help determine if architect or professional engineer is needed on a new construction, renovation, or addition project depending on the occupancy classification and size. Additionally, the handbook is available on our website under resources and publications. You can download a digital copy, as well as if you select the order materials button there at the bottom, it will send an email to me, and I will get that email and I can send you the handbook, and it won't cost you anything.
Hey, Allison, really
So
quick.
statute 81-3442 discusses the prohibited acts and penalties. It is unlawful for any person to practice or offer to practice architecture or engineering in Nebraska without being licensed in accordance with the NBEA Act, unless such practice or offer to practice is exempt under the Act. Additionally, it's unlawful to knowingly and intentionally employ or retain a person to practice architecture or engineering in Nebraska who is not licensed in accordance with the Act. There are a few exceptions. Some of these are engineer interns, estimators, technicians, other similar titles, as well as those exempt design projects based upon the occupancy classification and building area through Rule 10.3. Additionally, it is unlawful to use the words architect, engineer, or any modification or derivative of such word in its name or form of business activity, except as authorized in the Act or Professional Landscape Architects Act. Similarly, it's unlawful to advertise any title or description tending to convey the impression that an individual is a licensed architect or engineer unless they are duly licensed under the NBEA Act. A person cannot use or attempt to use certificate of licensure or seal of another person, so you can only use your own seal. Additionally, you cannot give any false or forged evidence of any kind to the board or to any member of the board obtaining or attempting to obtain a certificate. One second, looks like maybe I'll turn my volume up just to make sure.
Allison, can you hear me now?
I can hear you, yes.
Okay. People are asking about the PDF for the presentation. Can you just go over where that can be found real quick?
Yep, I'm gonna pull up so if you go to the WebEx page, there will be a webinars material section, and it'll have 2 files in there. And it should have those documents in there.
Thank you.
All right, moving on. And then lastly, it's unlawful to falsely impersonate any other licensee of like or different name. And then you can not attempt to use an expired, suspended, revoked, or non-existent certificate of licensure, or practice or offer to practice if you're not qualified. And then additionally, you cannot claim that you are licensed or authorized under the Act. And then simply, you cannot violate the Act. So any person who performs any of the actions that we just went over is guilty of a Class 1 misdemeanor for a first offense. and a class 4 felony for the second or subsequent offense. So what is the next step if it is believed to have it's believed you violated the act? 813444 goes over disciplinary actions authorized in civil penalties. So the board, after hearing and upon proof satisfactory to the board, may determine by a 2/3 majority vote that any person or organization has violated the act or any rules or regulations. So then upon a finding that an individual has committed a violation, we're going to go over the following actions that may be taken against the individual or organization upon a 2/3 majority vote of the board. So these penalties can be an issuance of censure or reprimand, suspension of judgment, the offender can be placed on probation, placement of a limitation or limitations on the licensee holder, and upon the right of the licensee holder to practice the profession to such extent, scope, or type of practice for such time and under such conditions as are found necessary and proper, or imposition of a civil penalty not to exceed $10,000 for each offense. The amount of the penalty shall be based on the severity of the violation. Another penalty is entrance of an order of revocation, suspension, or cancellation of the certificate of licensure, a cease and desist order, imposition of costs as in an ordinary civil action in the district court, which may include reasonable attorney fees and hearing officer fees the board has incurred and the expenses of any investigation undertaken by the board, or it can be dismissed. So next we're going to go over the complaint process and the investigations. So how to file a complaint. The board gets complaints in a variety of ways. The majority, we receive complaints from other state agencies and the public. Anyone can file a complaint with the board, even if they're out of state. The following listed are ways we have received complaints. So from members of the public, professionals in the building industry, other state agencies, professional societies, and firms. Some of the complaints received include when architects and professional engineers are not involved in projects that are not exempt from the act, if a project has invalid seals, or a possibility of professional misconduct on behalf of a licensee organization. So to uphold our mission and goals, the board works very closely with other state agencies and officials across the state that share our mission to protect life, health, and property, and to promote public welfare. By working with these other state agencies and officials across the state, we can ensure we're getting out the correct information to the correct people so that the public is better informed and served. So some examples, we have the State Fire Marshal, Department of Health and Human Services, local building officials, and the Department of Environment and Energy. So how to file a complaint. Complaints can be filed with the board after completing our complaint form, and you see it to the right. This form is available on the board's website. All information remains anonymous. Any contracts, technical documents, or other evidence supporting your complaint can also be submitted with this form. We recommend providing as much information as possible. The completed complaint form and supporting documents can be emailed to the board's compliance officer, Amy Habe, or mailed to the board's P.O. box. So the board doesn't investigate anonymous complaints unless it's disclosed evidence of an immediate threat to health, safety, and welfare. Additionally, the complainant cannot take over the project they are making the complaint against. So for example, if I submitted a complaint against the project owner of project ABC, I can't take over as that project owner for project ABC. So looking at investigations. So once the board receives a complaint that a person or organization is alleged to have violated the act, the compliance officer will reach out to the complainant to gather more information. They will also contact the respondent and gather as much information about the complaint. This can include possibly visiting project sites if necessary. So once the process is gone through, the information will be gathered and presented to the board. Have the option to initiate a case and continue investigating the complaint, or authorizing mediation on a project, or close the complaint. Additionally, if the board receives a complaint regarding alleged incompetency by a licensee, the board investigates the complaint in a similar process. So one
Allison,
way, sorry,
can
go
we
ahead.
pause for 1 second? I just want to jump in here and answer a couple questions that have been asked. Um, uh, I want to say just very briefly, I think what the law says about a licensee who um, makes a complaint, what the rules actually say is that you can't be involved as the architect or professional engineer of record with that. So I just wanted to clear that up, something that Allison said earlier. The other question from Dennis that I wanted to answer here, typically if the board does find that or takes action against a licensee, we typically, as a matter of course, do report those to the NCAAS and NCARD databases. They both maintain disciplinary databases, so unless there's some other extenuating circumstances, they are all reported to NCAAS and NCARD. So just wanted to add my 2 cents there. Okay.
Thanks, John. So next we're going to look at remediation. One way the board will bring a project into compliance with the act is through remediation. Remediation is an informal process used by the board to involve licensed professionals on building projects in Nebraska that are subject to the ENA Act. Typically, the project will require an architect if the project involves the practice of architecture, and a professional engineer if the project involves the practice of engineering. This ensures the health, safety, and welfare of the public is being protected. If deficiencies are identified, the remediation professional must recommend design solutions to remedy the issue. Involved parties cannot have ex parte communication with individual board members. So this means on one side only, by or for one party. So in our terms, this would involve an involved party in the complaint communicating directly with an individual board member about the issues in the complaint without the other party's knowledge. So under Nebraska Revised Statute 81-334, if a person or organization has committed a violation, one or more of the following actions may be taken against a person or organization. So issuance of censure or reprimand, suspension of judgment, placement of the offender on probation, civil penalties not to exceed $10,000 for each offense, cease and desist order, imposition of cost as in an ordinary civil action in the district court. So I know we touched on all those a little bit previously. The board usually does not take action, but if someone chooses not to comply with the remediation process, the board has the ability to take action against the project owner. Additionally, if there are other violations of the act or board rules, the board has the ability to discipline the individual using one or more of the penalties listed above. So additionally, disciplinary actions will be reported to NCEES and NCARB. This reporting allows all jurisdictions to access this disciplinary information. And if you are a professional engineer, you will lose your model law engineer status for any discipline action. So the cost of noncompliance following the ENA Act can help Nebraska citizens, this includes licensees, organizations, the public, anyone. This helps them comply with state law, protect property, protect persons on and using said property, and prevent damage or liability from improperly constructed buildings. When the ENA Act isn't followed, property owners and developers may be liable if a structure was built in violation of the Act and subject to fines and civil penalties authorized by state statute. So the board has those penalties previously listed to use if necessary.
Let me add a couple things here, because I think we're at the end of this section of the presentation. So a little more about the remediation process. Typically, that occurs when the board is aware of a project owner who should have involved architects and/or professional engineers on a project and didn't. How the board likes to approach those is that because there's a potential project that's a threat to health, safety, and welfare, the board's first priority is to fix that project before they even think about penalties. So the board has this remediation process in order to get that owner to engage the required licensees to review the project, see if there's any deficiencies. If there are, that project owner has to correct those, and then the licensee verifies that. And then once all deficiencies are removed, then the board will dismiss the complaint because, in the board's view, that project now complies with state law. And it's only in the cases where the owner is dragging their feet and doesn't want to engage licensees for whatever reason that the board then thinks about taking those next steps about issuing a cease and desist order, for example, to um, stop occupation of the building. So the board, again, really likes to work with the project owners and work with them to engage the licensees to get the project back into compliance with the act. Okay, I'm done.
Good information. All right, so next we are going to go over some case studies regarding different types of investigations, and then some little reminders regarding the violations that are the reason for these investigations. So the first case study we're going to look at involves the informal process for unlicensed practice. So this project involved the construction of a 4,140 square foot building. This building was classified as an A assembly occupancy under the state building code, which typically requires an architect if the project involves the practice of architecture, and a professional engineer if the project involves the practice of engineering, and the building area comprises 1,000 or more square feet. Plans were not clearly marked draft for preliminary submission and review and didn't appear to have the seal of a Nebraska licensed architect or engineer. The board reviewed the project and determined it constituted the practice of architecture and engineering and was not exempt from the act. Architectural remediation was authorized. The board determined that it constituted the practice of architecture. It didn't constitute the practice of engineering. So architectural remediation was authorized. This required the engagement of a Nebraska licensed architect as a remediation professional. So the remediation professionals review project plans and the structure to identify if there are any design deficiencies, and if there are, they will recommend corrections as necessary. Then the remediation professional will prepare and seal a letter to the board describing their review and conclusions about deficiencies. So then the project owner did engage a Nebraska licensed architect to correct the deficiencies. The remediation professional reviewed the project, corrected the deficiencies, and submitted a final letter confirming the project is in compliance with the ENA Act. All deficiencies have been removed, and they took responsibility for the project. Because of this, the project owner did engage the Nebraska licensed architect. They completed the remediation, corrected all deficiencies, and the complaint was dismissed with no disciplinary action because of the successful completion of the architectural remediation.
So I just want to jump in really quick, going back with that case study. So this is a majority of projects and procedures that the board sees is the board is notified of a project like or possibly not in compliance. The board reviews it, authorizes architecture or engineering remediation as necessary. And then really rule 8.4 is the process that is done next. The licensee engages the required licensees to go review the project, identify deficiencies. Something new that 8.4 has added to our recent rules change is that it requires a final letter from those remediation licensees. So initially it was that it wasn't in rules, but it was the process we did. But the remediation licensees have to submit an initial letter to the board identifying their involvement, any deficiencies, and possible corrections that the owner can do to remove those deficiencies. And like Allison said, once all of those, the owner states those deficiencies have been removed, it's required that the remediation professionals review the project again and ensure that those deficiencies have been reviewed or removed, excuse me, and then a final letter to the board indicating the project is in compliance and that remediation licensee is taking responsibility for that project must be submitted. And those letters are sealed, signed, and dated. So they are an official record for that project and that project owner.
Right, yes, more good information on that. So then next we're going to look at the responsibilities of the remediation professional. So as noted on the previous slides, remediation was authorized for a project that was determined to be subject to the act. The remediation architect reviewed the project and identified several deficiencies, including immediate concern for public safety. The remediation architect informed the project owner of the deficiencies and solutions to correct them. Once the deficiencies were removed, the new documents were sealed, signed, and dated by the remediation architect. And then the remediation architect submitted a final letter confirming the project complies with the act, confirming all deficiencies have been removed, and took responsibility for the project. Like Amy said, that document is become on official record. They seal and sign and date it to show that they take responsibility, all deficiencies are removed, and it is now in compliance with the act. So next we are going to look at a formal process investigation, and this one is regarding continuing education. So a licensee submitted their renewal for their architectural license and paid the fee for it. With the renewal application, the licensee attested to satisfying the mandatory continuing education requirements. Later, they were selected randomly for a continuing education audit. Initially, the licensee asked board staff what the penalty was for not completing the continuing education audit, and board staff informed the licensee that not completing the audit would be considered disciplinary action, which could include license suspension, fines, and other penalties, such as the ones that we previously went over. The licensee then submitted their continuing education log for the 2022 to 2023 renewal period. They identified 19 continuing education courses in the amount of 32.5 hours. So the continuing education audit documents were reviewed. The reviewer found discrepancies in the hours earned and certificates that were not signed by the instructor. So then the reviewer contacted the licensee for clarification. The licensee stated they spoke with the course instructor and the instructor agreed to fix the discrepancy on the certificates originally submitted. The licensee then submitted a revised continuing education log and 19 certificates, which included wet signatures of the course instructor's name and consistent hours earned on the certificates. The board completed an investigation into the matter and found that the licensee did not complete the 3 courses claimed, did not complete 3 courses that they had claimed, as well as the licensee did not speak with the course instructor, and the course instructor did not sign the certificates or fix the PDH discrepancy. A formal hearing for disciplinary action was held. During the hearing, the licensee admitted to forging the course instructor signatures and changing the hours earned on the certificates. Licensee had recently signed a settlement agreement for disciplinary action from August 2022, where the board found them incompetent to practice structural engineering. This agreement also stated that if the licensee was found to violate any other separate provision of Nebraska law or regulation that governs the activities of licensed architects and engineers in the state of Nebraska within a 5-year period of executing the settlement agreement, the board may consider the matters referenced in the settlement agreement in imposing any subsequent penalty. As a result of the current violation and the past settlement agreement, the board voted to revoke both their engineer and architect license in Nebraska, and they are ineligible to apply for licensure to practice architecture or professional engineering in Nebraska for 5 years. So after discussing a formal investigation regarding continuing education, we're going to review some board rules regarding continuing education hour restrictions, web-based offerings, and reporting the correct information. This is where we see most issues when it comes to continuing education audits. So web-based offerings provided by the entities below may constitute all of the biennial education requirement. So these entities are the International Association for Continuing Educational Training approved providers, institutions of higher education that have an accredited program in architecture or engineering, professional engineering or architectural societies, technical societies and associations recognized at a national level, governmental agencies, or NCARB and NCEES. An important reminder that the board does not pre-approve CE courses or providers. If a CE provider says they are approved in Nebraska or all 50 states, that is a red flag. All right. So web-based offerings from a provider not listed previously in 931 may constitute no more than 1/4 of the biennial education requirement So that's 6 hours for architects and 7.5 hours for professional engineers. The exemption to this rule is if web-based offerings is led by an instructor and attendees and allows the instructor and attendees to give, receive, and discuss information in real time. If that's the case, then it is not restricted. So when discussing professional conduct regarding continuing education, Rule 5.5.7 states licensees shall not deliberately make a materially false statement or fail to disclose accurate and complete material facts requested by the board in connection with the licensee's application for licensure or renewal or otherwise requested. So when discussing continuing education, examples of this include reporting that the mandatory continuing education requirements have been satisfied when they have not, as well as attesting the information is correct to the best of your knowledge, again, when it is not.
All right, Allison, before we go into anything else, let's answer some of these questions here in the chat box. I think we discussed that wet signatures on certificates aren't common these days, which is fine. Electronic signatures are okay. NCES or AIA tracking for CE is completely appropriate. Which is, so Rule 9.5 in the handbook discusses record keeping. And the rules require licensees to keep track of the documents on a CE log. And it states specific information that needs to be on that log and attendance verification. So this can be in the form of completion certificates or other documents supporting evidence of attendance. So some of these questions on here say, well, I don't get certificates. Just like this webinar, an email verification is fine. If you have things like a program or things of registration, things of that nature, something that can support your the evidence of attendance. If you have, or you can have records maintained by NCES or NCARB. So if you have if you submit all of your documents to NCES and you're selected for an audit, you just have to submit your NCES records. Otherwise, if you don't have NCES or NCARB records that keep track of all of that, you must submit a log with attendance verifications. Let's see. Good way to make it easy for audits? Absolutely. Do a log with the information required and submit your attendance verifications along with that in order by date of completion. Nebraska actually requires that, and if you're selected for an audit, there's instructions on how to submit that information, but it is required that that information is listed in order by date and in when you submit the certificates, they must be combined into one document, also in order by date. It is a monster to try to figure and match up things, so it is required that this is submitted appropriately and per the instructions on the audit notification. Any others that we didn't necessarily answer?
Yeah, there's a couple here that I want to jump on. So
Okay.
Ron asks if NCARB web-based CEU courses without personal interaction are unrestricted. That is, yes, that you've interpreted that rule, which is it's now rule 9.3.1. So they would be they're called out specifically in that rule. So you could get all your hours that way, Ron.
But let's be clear though too, that it has to be AIA that is providing the education, not an AIA approved provider. So for example, like PDH Online is approved by AIA, and if PDH Online is the one hosting the education, even though they're AIA approved, that still could, if it's not AIA providing the education, that PDH Online is a restricted provider.
Yeah, that if you see an AIA approved provider, that means nothing to us at the board. So just I would caution you, just because you see an AIA approved provider, we don't reference that anywhere in our rules. And so I would just make sure everyone is aware of that.
Real quick, Brian asked if this if the seminar is submitted to AIA for credit. We do not submit it. If you're selected for an audit, you can provide your AIA log plus the email confirmation from here of your attendance, and that will be counted towards things, or counted towards your total.
Lawrence asked if the board does not approve CE credit for something submitted, can the engineer make it up? Yes, if they're selected for an audit and they're short, we don't accept some of the hours. Then typically, I think what the rules say that you get, we'll let you know how many hours we calculate that you're short, and you'll get 60 days to get additional CE credit. So there is a window there. If we do not allow something, you will get additional time to make that up, yes. Unfortunately, because to address Harlan's question, aren't you putting professional in jeopardy when they select a course? Because the rule says that we can't pre-approve any courses, that's the way it's been in Nebraska for at least 25 years. So it is what it is probably the best word I can give you. And in particular, this course, we can't say definitively that the board is going to accept this course. Is it probable? Yes. But because of that rule, we can't say yes, it will, or no, it won't. Yeah, we will talk about carryover too. I wanted to answer this question. So licensees can carry over up to half from the last cycle. Can that mean any excess in each cycle can be used for the next cycle? Just think about the carryover rule. You can only carry forward from one renewal cycle into the very next renewal cycle. You can't use carryover from 2 cycles ago. So if you're audited and you need that carryover, you actually have to submit 2 and maybe more periods of your CE, because if you're calculating carryover or wanting to get credit for carryover, we need to see that you can actually claim it. So the carryover only goes into the very next renewal cycle.
I see we have a lot of questions about continuing education, and I don't discount that they're not important. We did do a webinar on continuing education not that long ago. I believe it's on our YouTube channel. That may answer a lot of these questions, as well as chapter 9 in the handbook. We are approaching 50 minutes, so I don't want to take up, we'd have quite a few slides left, so I would like to get through them. The board may have a continuing education webinar in the future, but I would encourage everybody to look at the YouTube channel and look over chapter 9, as well as the links on our website under each license or engineers and architects tab for additional information. But I would like to keep this going. And if you have specific questions, feel free to email myself or the compliance email. And we can try to get those answered, but I don't want to take any more of the presentation time if possible.
I just want to say this about AIA approved courses. It's not that they don't count. I'm just saying, or they don't potentially count. What I'm saying is that the fact in and of itself that it's the course is an AI coming from an AIA approved provider it's not referenced to our rules. There's no special consideration given to an AIA approved course. So it's not a blanket AIA approved courses don't count. That's not the case at all. Just that in and of itself, AIA approved courses don't necessarily rise to any special level in the board's rules on continuing education. That's all I'm saying.
We are going to continue. Next, we're going to look at a case study that there is no violation. There was an allegation of a project violating the act due to it not being prepared by or bearing the seal of a Nebraska licensed architect or engineer. It was classified as an A-assembly occupancy. The project owner received the communication from the compliance officer regarding this, and they contacted the compliance officer within a week of the letter requesting clarification, and they provided necessary information within the 2 weeks. Upon review, it was determined that there was no violation of the act and the complaint was closed. And this also shows the importance of timely communication. Just really helps us keep things going along, as well as getting your project to keep going along as you would like. All right, next we're going to look at plan stamping. This is where licensees are brought in at the end of a project to give a cursory review of a project's technical documents and stamp them for submissions to local building departments and other permitting authorities. So this example discusses a draftsman designing a project subject to the act without being a licensed design professional. Licensees were not directly involved throughout the preparation of technical documents. The board reviewed the project and determined it constituted the practice of architecture and engineering and wasn't exempt from the act, and architectural and engineering remediation was authorized. So minimum construction phases services were not being provided on this project, allowing for design professionals to be engaged. So consequently, the project owner may still be engaged in the unlicensed practice. The board found no formal administrative or legal action was warranted. They issued a letter of caution to inform them to use greater care when preparing technical documents related to projects that require the involvement of licensed design professionals. So licensees are responsible for providing direct supervision of work on a project they're assigned to. Board Rule 6.4 states that to exercise full professional knowledge of and control over work, a licensee in direct supervision must have and exercise authority to review and to change, reject, or approve both the work in progress and the final work product. This is done through a continuous process of examination, evaluation, communication, and direction throughout the development of the work. They must be personally aware of the project's scope, needs, parameters, limitations, and special requirements. They must be capable of answering questions relative to the architectural or engineering decisions made as part of the services provided. And they must be reasonably satisfied with the product of the services rendered and accept full responsibility for the work. So some good practices to ensure responsible control. Review the processes you use to implement design solutions and develop clear expectations for on-site personnel who collect the data and observations for your projects. Also, maintain a clear chain of custody with the information you receive, such as photos, measurements, etc., when identifying thresholds that would necessitate follow-up or further investigation. We discussed a little bit construction phase services. So property owners that allow projects subject to the act to be constructed on their property and don't involve an architect or professional engineer, they may be engaged in the unlawful practice of architecture or engineering. These property owners are no longer potentially practicing architecture or engineering if they employ or cause others to employ licensed design professionals or persons under the direct supervision of licensed architects or professional engineers to furnish at least minimum construction phase services with respect to the project, or if the project is exempt from the act. So construction phase services include at least the following services. This includes visiting the project site on a regular basis as necessary to determine the work is proceeding generally in accordance with the technical submissions submitted to the building official at the time the project permit was issued, and processing technical submissions required of the contractor by the terms of contract documents. This term does not include supervision of construction, review of payment applications, and several others listed there. Additionally, observing versus inspecting when it comes to this. Design professionals have an ethical and legal obligation to properly observe and inspect a project. Observing helps design professionals estimate the amount of completed work and verify compliance of the project. And inspecting is a higher level of observation that entails closely examining a project for judging qualities and conditions. So case study regarding competence. A complaint was initiated for a licensee for incompetence due to practicing structural engineering without proper knowledge and skills to do so, which resulted in the collapse of a building. When the board requested information from the licensee to show training, education, and experience to practice structural engineering, the licensee failed to do so. An expert witness found that the licensee lacked necessary understanding of structural engineering to be able to practice it. As a result, a settlement agreement was proposed to which they agreed. The settlement agreement had the licensee cease and desist from structural engineering and issued a $2,500 civil penalty.
Hey, Allison, real quick, we are at 1 o'clock. So if those that want to stay or can stay we do have some more slides. We will give credit out to those who stay as well as those who have stayed for the hour. So we'll go through the next few slides quickly as we can. And if there's any other questions, please reach out to follow up.
Okay, so again, reviewing competence, just ensuring that licensees act within the reasonable care and competence to apply technical knowledge and skill. Licensees shall undertake and perform services only when they are qualified by education, training, and experience in the specific technical areas. And they shouldn't sign, seal, or attest to any work that they don't have professional training and experience in. So going over a case study with organizations practicing without a certificate of authorization, they notified the organization, they responded by the deadline and submitted their application for certificate of authorization and paid the in arrears fees. And the complaint was dismissed based upon them getting all of that settled with the form as well as the fees. There's just some listed about why you would need a certificate of authorization. This is going to be in Board Rule Chapter 7. I'm going to skip over it though. We're going to discuss coordinating professionals a little bit. So coordinating professional is needed, when there's more than one design professional on a project. So if there's two professional engineers, one engineer and an architect, and so on, one needs to be designated as a coordinating professional. This coordinating professional could be a licensed architect, landscape architect, or professional engineer. So the coordinating professional is responsible for reviewing and coordinating technical documents prepared by others for compatibility to make sure the project designed. So the big thing that we see is making sure that the seal for the coordinating professional is in compliance with the act. So that involves using their seal, their signature, the date, and then the language below it saying I, name of licensee, and the coordinating professional on the, and then the name of the project. This doesn't necessarily indicate responsible charge or direct supervision. It just signifies the main point of contact for anyone needing to get in contact with someone regarding the project. So their role, coordinate communication between design professionals, act as a project liaison, and verify that all design disciplines involved in a project are working in coordination with one another, and the corresponding discipline approves any changes made to the design in which life, health, safety, and welfare are not compromised. And lastly, we're going to look at technical submissions. So technical submissions that constitute the practice of architecture or engineering must include the project name and location. When looking at the address and location, we need you to be specific, be as specific as possible. If there's no street address yet, legal descriptions are allowed. We just want to make sure that we want to be able to give any reasonable person the ability to find the project. If we don't have this information, this could lead to a violation of the act and could lead to discipline. So if it's not being performed through an organization, we must have the licensee's name and contact information. This slide shows what those documents must look like, with the seal, project name, location, and the licensee's contact information and address. I'd like to note that the board is currently establishing a policy regarding sealing large specifications that involve the work of multiple licensees. This policy is regarding instances when sealing large specifications involving the work of multiple licensees, where it may be cumbersome to coordinate sealing the first and last pages of each specification section. Each licensee may place their seal on a separate sheet placed at both the front and back of the specification, listing each section that the licensee prepared in accordance with the act. This policy is still in process, hasn't been approved, but when the language is done, communication will be sent out. So going through if their work is being performed through an organization, you'll need the organization's legal name or doing business as, their contact information, and their CA number. If you don't know your organization's CA number, we do have the licensee lookup feature on the website, which is updated weekly. Again, an example looks pretty similar to the non-organization one, except it does have the organization's information. Skip over that. So technical submissions. the licensee or organization information is required on each drawing, in the cover page and or first page of specifications, reports, studies, and other documents. So just kind of summing up those last few. And that is it. Thank you everyone who hung around. We kind of went over time a little bit. But did we have any other questions we needed to go over?
Yeah, there's a couple I want to answer here. Real quickly, reports, George asked, do reports and studies need to be signed or sealed? Yes, if the preparation of that involves and requires the practice of engineering or architecture. So those do need to be. Wanted to answer very quickly a couple others from earlier. Can a graduate engineer or architect call themselves an engineer or architect without first passing a licensure exam? Architects, definitely not. They can't call themselves an architect until they're licensed. Engineers are a little bit different. The protected term in Nebraska is professional engineer. So someone who just graduates from UNL with a mechanical engineering degree, they can call themselves an engineer, and that is not at odds with the E&A regulation. The other question I wanted to answer is, can an individual provide engineering services without becoming incorporated or an LLC? Absolutely. You don't need to set that one up. The decision to practice through an LLC or organization is completely up to that licensee. Okay, anything else, Allison?
I don't think so. If there's nothing else from you guys. Again, if you guys weren't able to locate the PowerPoint slides, feel free to email me at that email address and I'll send them over to you, as well as if you have any questions that didn't get addressed, you can send them to me and I can get them to the appropriate people. And yeah, hope everyone has a great day and thank you for joining.
Don't turn it off yet, Allison.
Okay.
Sorry, I'm just getting a couple more things.